Hi there. Welcome to Talk to Me Tuesday on a Tuesday. I'm your host, Madi B. And today we have yet another special show. We're going to talk about a much needed subject that's been going on in the news. And a lot of you guys that are watching may have questions, may have loved ones that have been affected by this, and just need to get a little bit more information. So today we will be talking about the opioids lawsuit. Something very serious, something that is going around out there. And we just have a lot of questions. So today we have a very special guest who is in the forefront, in the courtrooms, fighting for the rights of those that have survived over the opioids, pharmaceutical drugs. We would like to welcome Attorney Rochelle Guiton.
Hi, Madi. Thank you so much for having me.
Yes, it's a pleasure. It's a pleasure to have you on and really speak to those that are watching in regards to the opioids lawsuit, what it means. I know we get a lot of questions on our social media. You get a lot of questions from your clients. And I would like for you to be able to speak maybe more general, because I know, you're in this litigation and there's certain things you can't say, but something that would help that our viewers that are watching now. So for those that are watching now, a lot of our viewers have seen you on our social media and our website as a sexual abuse attorney here at D. Miller and Associates. However, you're representing another big docket opioids lawsuit. So tell me a little bit about the type of cases that you handle for your clients.
Sure. So first of all, thank you for the opportunity to talk about this docket. And you're absolutely right. I can't get into all the, minor details. I can't disclose any, client privilege or confidential information. But I do think that, and for anybody that's watching, this show could be helpful just by way of understanding the process, the timeline, things of that nature. And, why is this case taking so long? Those kinds of questions and things that some of our clients and maybe others out there just have in general. For myself, you're right. So my sort of niche docket has always been sexual abuse cases. I'm very passionate about working that type of docket. But in general, Madi, I am a plaintiff's attorney, and I've always been that way. Even as a prosecutor, I've coined myself and always said, as most prosecutors do, that I wear the white hat. If someone has been harmed in some way, some vulnerable person has, been taken advantage of, that, I like to be able to fill those shoes as the protector, as the advocate. And so this docket, when this came about and Darren Miller and I, the owner of our firm, discussed the possibility of being involved in this case, it was almost a no-brainer. Us taking on, a manufacturer like Purdue Pharma is like us working other dockets like the USC case, the Boy Scout cases, and taking on individuals and corporations that take advantage of people. And so our representation of these individuals who we filed on behalf of against Purdue Pharma in the bankruptcy and those that have been addicted to drugs like Oxycontin, it was a no-brainer for me. Yeah. I feel like that is still me pursuing my passion of being a victim/survivor lawyer.
Yeah, that's awesome. And look, I can't thank you enough for always being for the people, by the people, right? I know we always need, I say we, because it's, society, community, we always need an attorney like you that is our voice, right? With legal matters like this. So I can't thank you enough for that. Now, going into the opioids information, you just mentioned Purdue, right? My question to you is, what company exactly are we talking about, if not one or multiple, in regards to the opioids pharmaceutical drug?
Sure. That's a great question, Madi, because it gets kind of confusing because there are multiple manufacturers of Oxycontin. So Purdue Pharma is the specific case that we're talking about today. And it is one of the manufacturers of Oxycontin. And so that, I think that is sort of a difficult question just in the sense that, even for me, when I'm prescribed drugs, I may not know or remember who the actual manufacturer is at the time that I'm getting prescribed, right? When you're in need of that medication, you're not thinking who's making it. You're trusting that your doctor will prescribe you something that you need, that's warranted, and that it will help with your problem, your pain. And so I do recognize, that there are lots of individuals out there that were prescribed Oxy, and they may not know, or maybe even have the information at hand to know which of their manufacturers. But today we're talking about the Purdue Pharma docket. And yes, there are other manufacturers out there, that have produced similar drugs.
Okay, perfect. So that kind of clears up a lot in regards to what we're talking about. So now I want you to tell us a little bit about the opioid lawsuit. When did this start? When did this occur? There's been a lot of news that I remember seeing, oh my gosh, 2-3 years ago, me personally. But what made you as an attorney realize that you need to be a voice for your clients?
Sure. So I would say this started somewhere in the realm of like September of 2019 is when Purdue Pharma filed for Chapter 11 bankruptcy. So, they basically voluntarily filed for Chapter 11 bankruptcy. And just real quickly, Madi, not in every circumstance when someone files for Chapter 11 bankruptcy means that they're entirely broke, that there's no money. Mm-hmm. And it also does not necessarily mean that, they want their company to be completely terminated and ended. Sometimes, for example, like with Boy Scouts, there's an attempt to restructure the organization to make it better, make it work, and get them out of this bankruptcy. So that was the start of it, a voluntary filing of Chapter 11 bankruptcy. And I would say sometime in about March of 2020. So we're just over about 2 years in as far as our law firm involvement and when we began to get cases and represent clients on this particular docket. So we're about 2 years, I would say just 2 years in to this docket. And I know that just for them personally, for our clients, it probably seems like a very long time. And I know we're probably going to get to these questions later on the show, but, it's as far as a litigation is concerned for where we are with the case, it's actually moving very quickly. And we can talk about that, in more depth, but that's kind of how things got started.
Yeah, we definitely want to talk about that in depth because you have to think there's been a pandemic, there's been a pause in court system. So I want to talk about the timeline for sure, because I think that's important. I agree. That's really fast, and kind of kudos to you and your team to kind of keep the ball rolling, but we'll definitely deep dive into what that time frame looks like. Now, I want to kind of address like what has been in the news. There's been a lot of things on the news. As we know, there's good news and there's bad news, right? In regards to, let's say, misleading news, right? Maybe it's painting a certain narrative, but it's really not like that. So tell us about some of the things that have transpired and that have maybe progressed in this lawsuit with what's been going on and what you've seen out there.
Sure. So first of all, what I always say to my clients and hope that others, recognize this as well is that, unfortunately, we live in a world where, information is easily accessible. We can get to it very quickly, but it doesn't mean that the information we receive is always true. It's not always that the information is correct. And so, the media, some are reporting unbiased, right? Non-opinionated stories when they're, appearing in court or receiving information from attorneys that are involved. And that information is good information. But not in every case, right? We live in an age where there's just a lot of biased, opinionated, articles that are coming out there. And I just always want our clients to know, don't throw your caution to the wind. You don't always, it's in the media that we, even though you may not hear from us, every week, or every month that we're still working diligently on their cases, that that we're working hard behind the scenes. And so I always just caution them on the information that they're receiving from the media, and just kind of have an air of suspicion, because just because it's there doesn't necessarily mean that it's accurate and true.
Yeah. And look, I'm going to kind of ask an additional question because you just said that. And I know a lot of us, when it comes to legal, we're thinking every single day, or even in the court system, every single day, the court is designating their time on our case or this case. But the courts also have other cases, right? So naturally, like, welcome us into your world on how really this works, because there is kind of some dead time with judges in the courts and stuff like that. Talk to us a little bit about that real expectation.
Yeah, well, and I'm going to reframe that, because I wouldn't call it dead time. And the only reason I would say that is because we're busy, right? Courts, and this is in general, this is not just with respect to the Purdue or the opioids cases, just in general, courts and lawyers, are busy. Not to say that, you shouldn't get those updates, because you absolutely should get updates and know what's going on with your cases. But for the most part, the courts are juggling several dockets at a time. And so they have a calendar, right? And so those court dates are going to be calendared. The court may take time if they have a hearing of some kind, or motions or objections and things that are filed for various reasons. And the court may not make decisions as quickly as we would like. Lots of times the judges will say something to the effect of, I will take this under advisement, which means I'm going to take everything that you've said. I'm going to go, in my chambers, and I'm going to study it. I'm going to read it. I may do some research. I may have my law clerk do some research, and then I will, come up with my answer, decide, make my determination. They may come back critical of what information was provided and say, hey, I'm not ready to make my decision. I need to know answers to this, this, and this before they would decide. And then you'll have another court date come, or the court may need time. And so then that may stretch it out for a bit longer. And it doesn't mean that they're slow. It just means that these are very important decisions that they have to make that affect, like in Purdue, affect thousands and thousands of people all over the country. And so I like to think that when judges are taking their time, that, they're doing the right thing. They want to make the right decision. And so those things take time, right? And so while those judges, the judges on those various dockets are making their decisions, we're working on other things as well. I could be working on other dockets, other clients. I could be saying, here, if the judge is making this decision, I want to be prepared for the next step. And so then I'm preparing for those next phases of what I believe are going to be the next transition of that particular docket. And so I would like to think that we're always evolving, always working in the background. And it's just really hard, as the client, I can understand the anxiety, because they may not be able to pick up the phone and call me and speak to me about it each day, or they may not be getting an email. It's kind of like that, cliche statement, no news is good news.
Yeah.
It doesn't mean that nothing has happened. It doesn't mean I'm not working. It just means that we're in waiting. There's just a process, whatever that point is in the case.
Well, let me tell you that is a very, very well put out, explanation that allowed me to see a little bit more clear on every perspective, on the attorney's perspective, on the other side, the other attorney's perspective, the judge. That is very clear to me. And also you have to be ready and prepared, right? If they don't give you either party time to prepare, to research, to allocate the facts, then, the decisions are kind of made, with not enough organization or preparation. Right. So I love the way you put it into perspective for me to definitely understand.
Well, and that's a great point, Madi, that you would add the preparation time to get to those hearings, to draft those motions, to file those motions, and to keep perspective on dockets of this size, right? I'm only one lawyer. There are hundreds and hundreds of lawyers that are working in this case the way that I am to represent their clients as hard as I am, as well as we are. And so I would say, they're doing the same to practice. So let me give you an example. The Boy Scouts cases, we just had a confirmation hearing. Now, the court has not made a decision on whether or not to approve the plan just yet. And we are waiting to hear from the court. But that hearing took, in essence, about 4 weeks. It's a 4-week hearing. And so every day, that the court and the lawyers on both sides have to be prepared with witnesses, questions, for direct and cross-examination. They have to be prepared with documents and exhibits and things of that nature. And this is going on for a 4-week period. So it's a really tedious and laborious, litigation. And so it's quite a bit of work. It takes and I would say more so the time that it takes to do these things. And, even if the attorney may not be questioning that witness that day or presenting evidence that day, they're still on listening, keeping track of what's going on, making sure that they're ready for the next phase of the case and things, whatever is, trying to think ahead,
Yeah. And look, I just think about whenever those hearings that you're saying takes up, it was 4 weeks. Once it's on the calendar, you as an attorney have to really prepare and have all your facts. So I could just think you countless nights burning the midnight oil to ensure you're ready by that day. I'm assuming, right? I don't know, but I just can think, oh my God, you have to be prepared by that day.
Right. Well, and there's levels of involvement, right?
Right.
If you have hundreds and hundreds of attorneys that are involved on a docket, not every one of us is going to be able to speak on that docket and represent each one of our single clients. And so what happens is there are, committees and coalitions and lead groups of attorneys that are formed. But we are still preparing, planning, meeting, making sure that even if I'm not able to speak specifically about my client, that their particular issues are being addressed in that docket. And so this is how it's really I would say a very tedious structure and organization that has to happen when you have, over 100,000 claims that are being, litigated and making attempts to meet a resolution. So it's a lot of work that goes on in the background that unfortunately, our clients aren't always able to see. And so I'm kind of glad that you're asking these questions so that they can kind of know, that it's not just your case that we're working on. We're working towards resolutions on all of these cases and trying to make sure all these dynamics and all of these issues and things are met, if that makes sense.
Absolutely. And we're going to continue on with the questions here in a minute, but I do have a comment that, Rochelle, I do want you to kind of address. And just for those of you guys that are commenting, just be mindful. There might be some things that Attorney Rochelle Guiton may not be able to answer publicly, and you'll make your discretion on that. So we do have a comment saying, I have a case. They want immunity, though. I heard we would be able to confront Purdue. Can you explain on what exactly this means, or is this something that you can answer currently?
So I think that's a lot harder to answer than, it seems. I have a lot of follow-up questions before I can answer that question. If they are our client, I would suggest a private message to Madi, your team, if it's possible, so that I can hop on a call and answer that particular question with regards to the Purdue case. So that is, and this is maybe an answer to a previous question that you asked when you talked about what's going on in the media. So one of the things that we're dealing with right now and what largely affects the timeline of the case is an appeal that's currently pending. And one of the things that is going to be addressed with regard to the appeal is what we call third-party releases. And that could, in effect, give some form of immunity to the Sackler family and others, what we call non-debtor defendants. or debtor defendants. It depends on which third party we're referring to. So first thing that I'll throw out there is that affects our timeline in the sense that, one, we're still waiting for the hearing to happen. And when you file appeals, it takes a long time. This appeal has been requested that the briefing be expedited. And so I expect that the hearing will be had at the end of this month. If I'm not mistaken, that's April 28th. And so the hearing would be had, but the court then, just like we talked about before, would take their time in making that decision. And we will know when they're going to give us that decision, right? And so that's one of the things that we're working on, specifically to this case, the Purdue Pharma bankruptcy. So the comment, I'm not sure if that's specifically regarding this bankruptcy case. There are other various litigations, lots and lots of other litigation going on across the country about this case. And so I would need to know a little bit more about that before I would be able to answer. And then I also want to be really careful about just giving like really specific legal advice with regard to your case on, a public show.
Absolutely. Absolutely. As every viewer would appreciate that too. So if it is specific, and if you are represented by either D. Miller and Associates, which would be Attorney Rochelle Guiton, please send us a direct message. We do have a full-on dedicated team that gets directly with the attorneys to ensure that you get your questions answered and fulfilled. It sounds like, for me, and I'm not even the client, there's more questions to have before landing to that answer, right? So,
I'm sure there are lots of questions. The first thing, obviously what I would want someone to do, and I don't know if this person that commented is represented. If you're represented, I would suggest, making sure that you ask your attorney those specific questions. And so I hope that I've helped in some way to just kind of explain, that there are various litigations out there and things, different dynamics, different rulings and requirements on all of those cases.
Yeah, definitely. Now, we're definitely going to move on to the next part. Now, earlier you said that this case has been pending since September of 2019, and you began accepting cases in about, can't remember, but I think you said March of 2020. That's roughly about 2 years from right now. So talk to me about what has happened and the process of the 2 years and the length of time. Tell us a little bit about that length of time. Let's talk about it here.
Yeah. So first of all, 2 years seems like a really, really long time. It does. It can seem like a really long time, especially to someone who's been harmed and has been dealing with the addiction and the injuries that have come, because of those addictions, the harm that they've experienced. It seems like forever. So I certainly don't want to make light of that or minimize the time, because 2 years is that's a chunk out of your life, right?
Right.
However, if we're looking at the grand scheme of things and how litigation works, 2 years is not a long time at all. In fact, it's moved and progressed very quickly, considering where we are. Yes, I would say every attorney, legal mind involved in this docket would probably agree with me right now by saying that we wished and believed that this case would have been resolved sooner, that we would have been able to submit our claims faster, that we would have seen settlement sooner, and that's just not the case. I would say that even for me, just as much as my clients want a resolution and a settlement, I hope the same for them. That we're always wanting the case to progress as quickly as it can. Quite frankly, that's the right way, right? Because of what they've experienced, that you would hope that they could get a quick and fast, fair, just resolution. But 2 years is very quick in litigation. If you look at other, mass tort cases, some of them take anywhere between, I would say, 3, sometimes 5, even 7 years to settle or to be litigated, depending on what those circumstances are. bankruptcy in general is a faster case resolution because of the dynamics of bankruptcy. But I wish that I could, snap my fingers and make things happen faster and quicker. It just doesn't work. It doesn't work that way. Things happen in litigation. For example, what has happened with this case, Purdue, we got a confirmation, right? And so our plan was confirmed. That's great news. And so the court was supportive of all the voting, and we can talk about that too. That our clients took the time to understand the plan and what the dynamics of the case were. They put in their votes, and their votes were tallied in support of the plan. It's great. The court confirmed it. However, there were objections. The bankruptcy process allows a time period for people to object to the plan and allows those people to be heard. And quite frankly, this is all in fairness of what the judicial process allows for, to allow people to be heard and make sure that the courts and everyone is doing the right thing. Now, is it always what we want to hear? No, absolutely not. Is this the way that we wanted things to go? I would say no, but I think that we feel good about, what is happening. We've taken the right measures to, fight the objections. And here we are, coming into the end of April, and hopefully we'll have the resolution that we're all expecting and hoping for. So, just to say with regards to those timelines. Now, what has been going on all of these 2 years, right? And one of the most, I think, confusing things for our clients is that, they sign up, we accept their case, we say, hey, I'm going to represent you. We're going to file your claim. We fill out a POC, what's called a POC form, which is really the proof of claim form. Okay. They provide us with all the information of, the details of their addiction, the details of their injury, where they were prescribed these drugs, and, things of that nature. They provide us with all the information, and we get those cases filed. And in their mind, me having accepted and filed their case, they're going, oh, I'm good. A lawyer has accepted it. They've got my case filed. But what's really, really important to know and recognize is that there is a process of making sure and ensuring that your claim is qualified. And so, of course, we work through that process. But in the hurry of getting those claims filed, it's not always possible to get those records in, at the pace in which we need to get that claim filed by the deadline. So what we will always do, is ensure that that deadline is met, that their claims are preserved. And then we take all of this information and we're all simultaneously, getting records. And we all know what happened in about, what was it, February of 2020, at least February, March of 2020, is that we all began to deal with COVID. And so I would say that considerably affected the rate in which we were able to request and receive records. Companies that not particularly ours, but others that slowed down. So when we're requesting records from all the different, vendors and prescribers and doctors, and those offices were, either closed or working limited hours or now short on staffing, all the various issues, correct? And then let's add to that there are, over, 90,000 claimants in this case who are all in need of those records. So lots of moving parts. Mm-hmm. And so this is not an excuse. It's just the dynamic of this docket that had to be dealt with. And I think for the most part, it has been, somewhat of a smooth process that we're all, transition very easily. Our office, thankfully, we were able to move remotely fairly easily. But, of course, that was just a thing that we had to deal with. Right. It's part of litigation, things that happen in the world, in our country, in our nation, and we have to keep things moving. correct? And so, that was part of what we were dealing with at that time. So that, in and of itself. Then there's the voting process, right? And I mentioned, like, so grateful that our clients, when we reach out to them, we were able to exercise their right to vote on that case. Right. And so we do spend lots of time, calls, text, emails, and those things. And I would say, if we have any clients out there, our main form of communication for updates, we generally will email those updates. So, if you don't hear from us, it really means there's not much new going on. But when you do, most likely you'll get an update in an email format. Or, of course, you can reach out to us and let us know that you're looking for more specific information about your case.
Yeah, look, I'm floored about the things that you're saying. The reason why is because I never thought about that. I never thought, although I know about COVID, right? I never thought about the effects that you as the attorney may have in trying to progress the case moving forward. And that's just very eye-opening to me. I'm kind of upset at myself that I didn't think of this, right? But, medical records and, these medical professionals got pulled away because of COVID. Some of them got called into the hospital. Some of them had shortage of staff. All of that has affected the process. However, I'm pretty proud that you, along with the other attorneys, have dealt with it to where this is still pretty fast in the litigation side. So I never thought about how COVID could affect a case, especially this one, but now it makes perfect sense of some of those hurdles you had to cross along the way. And I'm sure that
just add that dynamic to, I would say, most litigated cases, right? If you need medical records of any kind, this would have been something that you would deal with on that case. So just, this is things that we have to deal with in life and in litigation. It's sometimes that's the ebb and flow of it.
Yeah. Well, thank you for definitely speaking and explaining that very thoroughly. So we can really look at it in a completely different arena, right? On some type of hurdles that you have. Now, I really want to talk about the process of filing and qualifying cases. Okay, this is probably going to be another loaded question I'm throwing at you. And if you can kind of talk about the voting and how that played into the filing, but what did it look like for you and on this docket?
Well, just in a sense, and I kind of mentioned it in this last question as a part of that process, right? Is that, the biggest deal is making sure, initially, because in bankruptcy, you have a very short timeline to file the cases to preserve those claims. And you're not going to be able to get those records as quick as you would be able to file or need to file. So that would be the first thing to keep in mind. And so just because your case is filed does not mean that you meet the qualifications, to be accepted into that docket, to be accepted into that trust and receive a settlement. So, and maybe let me take that a step further. So the case gets filed and we continue ordering records. It might be that particular pharmacist is not in business anymore. That provider isn't in business anymore. It could be that their records retention policies required that they destroy the records because so many years have passed. Most pharmacies may not have information past, 7 to 10 years. And so it depends on, their retention policies, whether or not you're going to be able to get records. Another big dynamic of the opioids cases is that, there were lots of investigations into what we call pill mills. And this is something that I actually worked on as an assistant district attorney. A pill mill would be, a doctor or pharmacist, mostly, providers, if they're writing prescriptions for drugs and they're not actually diagnosing their patients with the need, right? And so then if you've got individuals who are now, unfortunately, and against their own, consent and volition, addicted to this drug, so then they are going to this this doctor who is easily writing these prescriptions, right? Wow. And so they're legally getting these prescriptions, and these doctors are not advising and doing, they're following their oath, right? And protecting these patients from this addictive drug. Well, there could have been, and hopefully there was, investigations into that by law enforcement, the FBI, and some of them have been shut down. So if they're shut down, getting those records is quite a bit more difficult, if not impossible. So we have to navigate, through that while also meeting what we call the trust distribution plan requirements. Let's talk about that for a minute. So when you talk about the vote, the clients vote on the plan. So there's a plan that's drafted and put, hopefully that's the plan that would be put in place. And they get an opportunity to vote on that plan. And those plans set out the requirements of what would qualify a claim. And so once, we find out, oh, this pharmacist doesn't exist anymore, or this pharmacist, no longer retains records. Let's see what we can do. How can we navigate, this claim and show that our clients have been prescribed this particular drug by this particular manufacturer, right? And be able to prove up their claims. And so those are the things that we have to work through. And of course, there are hundreds and thousands of claims, and those records are still in existence, and we're able to get those records and work through them and prove up those claims. But it just, it varies from case to case. It could also very well be a circumstance, like I mentioned earlier on the show, that particular person may have been prescribed an opioid, but maybe it was produced by a different manufacturer. And we find that out when we get those records, and then we work through it. So, lots of different angles, nothing that I would tell anyone to just really be, super concerned about, but just know that we're navigating through those different things so that we can make sure that we've filed good claims and will be able to support with documentation.
This is great information. I feel like I need a board behind me and draw the flow, because it is because I'm not in your world, right? It's a lot of moving parts, like you said. It might seem complicated for me and it might not for others, but I think that, hearing this really puts a lot into perspective. Some of the questions that I have, and maybe some of our viewers may have, this just sheds some light, and we just can't thank you enough for giving us this information. Now, I want to ask one of the big questions that a lot of our viewers would like to know, which is, when can we expect this to be over? Okay, when is this coming to an end? And you already know what the next question after that is, but before we go there, I want you to answer, when can we expect this to be over?
Of course. So I wish, I'm going to start out with this. I wish that I could give a definitive date of when this would be over, when we're able to submit claims, but we're not that far along for me to be able to say that. So I would have a better idea once the appeal process is completed and we have a ruling. We know what next steps will happen. And obviously, we are all hoping, especially I would say for sure, myself and my team are all hoping that this case will resolve, very soon, and that, the stars will align and allow us to be able to submit those claims before the end of the year. But I would say, absolutely keep in mind, even though we are able, even if we're able to submit those claims to the trust before the end of the year, there's still an allocation process, someone that would review those claims and make sure that, that they qualify, how do they qualify, and make decisions about settlement monies thereafter. So it is a process. It is, I would consider this a large project of sorts, and there are lots of moving parts. And I would say, lots of decisions are being made about how we can do that, when we can do that. But, without certain things in place, like, for example, the decision on this appeal. We can't lock in that timeline. So being patient, I would say, is, one of the key factors in, kind of dealing with this docket and most litigation. So not ideally the answer that I want to give, but
yeah. Look, and I think that also helps because you said a very important part, which every case is different, right? Every injury is different. Every addiction may look different, and damage model may look different from me to the next person, right? So it definitely makes sense that even after, there's still a whole nother process to allocating the proper, I don't know, would valuation be a good word, right, for each claimant, because each one is looked at differently.
Individually.
Yeah, yes. Individually. Yeah. Perfect.
That's correct.
So now I want to ask another common question that I'm seeing a lot on our social media. A lot of claimants and a lot of our viewers have asked a common question, actually frequently asked question, that stands out to me, is, when is this pharma payout or pharmaceutical drug payout going to happen? And I think you kind of answered it, but just to clear the air.
Yeah. I mean, I think the question is, Madi, like, when are they going to see their settlement? When are they going to receive money?
Yeah.
And I can't answer. I don't know the answer to that. I would say the best timeline or idea that I could give was, in my previous question, is that my hope that we'll be able to submit these claims rather quickly and, hopefully by the end of the year. But I won't be able to nail down a date or a time until we know what's going on with this appeal process, and with the appeal. And we're going to, respect the court and, the calendar that they've provided, that I think that everyone was on board with an expedited process, and we've been given that. So that's great news, that, we don't have to wait with the normal timelines. It can take months and months, to be even heard by the court. So we'll be heard hopefully before the end of this month. And that's the best timeline that, that I can give. And I hope that, those that are worried about that timeline, that they will just continue to be patient with us, continue to be patient with the process, knowing that we're doing our very best to get this resolved for them.
Yeah, definitely. Being in the legal world, things take time. It's not easy to give some of these answers. I know you as an attorney, and, a lot of people right now, Attorney Rochelle Guiton, are asking a lot of great questions, important questions, common questions, and other things that people are asking is they want to know, is there anything they can do to help speed up the process? Is there any documentation? Submit their own medical records? Do you advise anything that the claimant, the individual, can do to maybe speed up this process?
So the short answer to that is no, just okay. With regard to the timeline, what the courts will allow, the submission process, and when we can submit. I don't think that there's anything else that we can do or they can do, from home, what they're dealing with that can speed up the process. However, if I have a client out there that wants to provide more their medical records, and I would only say those that have not previously provided it to me, mm-hmm. and you're able to get those records and you want to provide it, I would easily accept it. It may be that I've already ordered your records. It most likely is that we've already ordered those records and they are either waiting to receive them or processing it, through our normal process of reviewing those records and making sure that we have everything that we need, going back and forth with the vendors, the providers, the pharmacies, making sure, hey, I asked for this. I want to make sure that I've received it and that we're getting what we need. Mm-hmm. So we do have a process for that. But if there is any information out there that you have not provided us and that, you think would be important to your case, I would say send that information. If you're able to provide records and you want to send that, we will always accept it. It'd be great if they could electronically email that information to us rather than, sending it through the mail. But of course, we understand. But yeah, I mean, I would say that's the only thing. Okay. But I can't say that we're really in need of that. But if there's the information is what would be, I would say, important. And I can't, reiterate enough. It's just that their patience and understanding through the process is, we are working on our end, and there's only so much of it that is within our control. We're working in the guidelines and the, instruction of the court and the process.
Yeah. Look, I loved reading that question because it just shows that your claimants are willing to help, willing to be like a team. I loved reading that right now because it just showed the unity from the attorney and the client and the willingness. So I can't thank you guys enough for just, putting that question out there. I know Attorney Rochelle Guiton, you feel the same way on just having someone ask, what can I do? Right. It may not be much, right, but just that question warms my heart on being able just to help a little bit.
Absolutely. Absolutely. I mean, I think, Mari, there's a lot of anxiety that comes in general when you hire a lawyer, when you go through litigation. And then this is one that is highly covered by the media. So, they're probably receiving, notifications from all the news sources and things and seeing, ads and other news media showing, videos and things of that nature. There are Netflix documentaries and Hulu and all of these things that are focused on opioids, and it creates an anxiety, I think. It's drawn a lot of attention to what's going on, which is great, right? This is what we want. We want the problem to, be focused in on and to narrow in on that issue. And when it gets the attention that it deserves, right, things happen, just like this case. And so that's great, right? But the anxiety that it creates in the people who have experienced this is their life. And so now, it triggers them. They've gone through trauma. Some people, it has, very well changed the dynamics of their life. And so my heart goes out to each and every person that is, dealing with that and the anxiety that it creates, because I do think that, hiring an attorney in and of itself, triggers, and going through this process, as a reminder of what you've experienced. So I am definitely in tune, and I appreciate, that they've hired us in this process, but just hope that they'll just be a little bit more patient with us and keep pushing forward, so that we can reach the resolution that they deserve.
Yeah. Now, one of the last questions that a lot of people also want to know, I know you kind of said that you cannot put a timeline on when the settlement will happen, but let's just say when the settlement does occur, what is the timeline for them to actually receive their money in hand? But before you answer that question, I would like for you to also explain, how long does this normally take on, your normal tort claim or normal injury claim? You have a lot of experience with, once the settlement has occurred or the value, how long after that? Because they think, okay, I could come tomorrow. If you had to give us an average, if you can, as an attorney, I don't know if you have any rules on that, but on average, the length of time expectation that you would say. So I know that's a loaded 2-part question.
It is. That's a loaded question, Mari.
Yeah.
So I can't give a timeline on what it will be like when they receive their checks. Mm-hmm. That part, I don't know that I have enough information to answer that question today.
Okay.
What I can tell you, just in general, when we talk about mass tort cases, I am familiar with dockets that take 7 years, 5 years, 10 years, to work through all those dynamics, through all those hundreds and thousands of cases, depending on what the tort was, and, in order to reach a settlement. And then to be able to have their distribution or allocation process to determine how much each case will get. And it's a long process. It takes a long time. So I'm really excited about where we are with the docket, even though I know that, it seems like a very long time. Again, I would just encourage anybody that, has some heartache or heartburn about how long this has taken, that we're really in a good place, in the sense that, we're really only 2 years out from, our filing deadline, just to really give perspective, was July 30th of 2020. So that was, the deadline to file proof of claim forms for this docket. So we've not reached the 2-year mark yet on, having to actually file the claims. And, so I think in that sense, we've been on a short timeline, even though it may not necessarily feel that way.
Yeah, absolutely. Now, look, the last question that I always ask on every show, because you've been on multiple shows, if you had to give any words of advice, especially to our clients, especially to the ones that are involved in this opioid docket, what would those words of advice look like?
I mean, I would just say, I think this has just been the theme from me, throughout the show, is patience, being patient, and understanding. And I hope now that this has helped, understanding the dynamics of litigation in general. We don't have updates every day. We don't have updates every week. Most, times I won't even have updates every month. And so generally we send those updates via email. So we'll send, updates of like what's going on. If there's some dynamic, something that's going on in the case, something that we want the clients to be prepared up for, some documents that we need signed. We typically will send that via email. And so I would definitely say, keep up with your email, make sure that we have good email addresses. And then just, understanding that, it takes time. It takes time. We care about your cases. We care about what's happened to you. If you have more information that you can provide for us, please feel free to do that. We understand your frustrations with timeline and, not being able to give those answers that that you're looking for. And I think that those days are coming. We will be able to answer those questions, just not yet.
That's fair enough. Well, Attorney Rochelle Guiton, I cannot thank you enough for coming on the show and talking about a much needed topic, which is the opioids lawsuit. You've provided a lot of explanation to the parameters of which you can, and clarity, especially for someone like me. I now see things a little bit different on this docket. So I just want to thank you from the bottom of my heart for coming on the show and explaining a little bit about your world in regards to this opioid docket. So thank you so much for coming onto the show.
Thanks for having me. And if I could, Marty, I just want to say that I'm so honored to be working on this docket, that, even coming from my work as a prosecutor, I just have always had a heart for survivors. Mm-hmm. And I would most certainly say that everyone that, every individual, not just our clients, but every individual that's involved in this docket and has filed a proof of claim form, they're survivors, and their family members of those deceased individuals are survivors. And so I most definitely appreciate and am honored to work on this docket. And I appreciate you, Marty, for having me on the show. Such a great idea to, just be able to openly and candidly speak about, the dynamics of this case and what's going on. So thank you so much.
Oh, it's such a pleasure. And we thank you for being on today's show. And for those of you guys that are watching, like Attorney Rochelle Guiton said, the main line of communication to getting anything out on this case is email. So please, please, please have your email on high alert. I also want to thank all of you guys that came on here, that are actively commenting, that are watching the show, but most importantly for sharing the show. The more you can share it, the more we can educate other members that are out in the community with these same questions. And I think it's very important. There's a lot of people that are involved in this claim. There's a lot of people that may have these questions. And so we just thank you guys for tuning in to Talk to Me Tuesday. And I want to thank you guys for being on today's show, Talk to Me Tuesday, on a Tuesday with your host, Mari B. Until next time.